Now, there are apart from this the legislations which are discussed with their key features, there are a number of legislations which one may come across in the course of the discussion on protection of environment, like the Forest Act of 1927, the Forest Conservation Act of 1980, the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006, and the number of laws like the mining laws, which also have serious effect on environment. Apart from that, we do have the environment impact assessment notifications, the coastal zone regulation notifications, noise pollution regulations, hazardous substances handling rules, etc. So, the legislations on environmental law in India is incomplete without a reference to the number of notifications, rules and regulations which are being issued from time to time. Now, look at the third part of the sources discussion, that is on judicial decisions. Now, if one looks at how judiciary responded to issues of environmental concern, one could see that in the initial years it was not necessarily on the context of environment, but at times in terms of the health concerns, the adverse health concerns, the issues were taken up by the court. If one looks at the state of Rajasthan versus G. Chawla decision, one could see that the use of amplifiers was regulated and the state legislation to that effect was upheld by the court in order to see that it will not be causing detrimental effects on public health standards. We also have instances where the judiciary has used the public nuisance provisions or the criminal law provisions regulating the nuisance. Accordingly, the judicial decisions were focusing on those issues, not necessarily on environment. But with the increasing awareness about environmental protection, the courts have used the constitutional mechanisms in order to expand the scope of environment protection in this country. For instance, we can see this expansion through Article 21 of the Constitution, which gives a right to life and liberty to the people. Article 48A, which is a directive principle of state policy, and Article 51AG, which is a fundamental duty. And the means which have been used for securing this right to environment was through the writ petitions or public interest litigations in the later on years. We look at a few cases to see how the discourse on environment protection happened before the judiciary of the country. We have an earlier case of 1980, which is called Ratlam Municipal Council versus Vardhi Chand, where the municipal authorities were put to task by the court when there were no cleanup of the sewage systems. In 1987, one of the major decisions came from the court in MC Mehta versus Union of India, where the court had for the first time laid down the rule of absolute liability, fixing a liability in absolute terms without any exception. So, we moved from the rule of strict liability, which is used in tortious claims, to a principle of absolute liability, not recognizing any form of exception. The court said in that case that if an enterprise is engaged in a hazardous activity, is a potential threat to the people working in the factory and those living in the nearby areas, the owner of the enterprise should be absolutely liable. This case is otherwise known as the Oleum Gasly case. Similarly, in 1986, the Rural Litigation and Entitlement Kendra versus State of UP, the court said it is for the government to decide in each case that to what extent exploitation of mineral deposits be permitted at the cost of ecology based on appropriate evidence. In that context, the court also said that the task of environment protection is not only the task of government, but also of every citizen under Article 51AG of the Constitution, because it is a fundamental duty which is the one which is casting obligation on the citizens in general. This was again a case of illegal mining in the Mussoorie Hills. So, the court said that it is for the government to decide how exploitation of minerals could be permitted without compromising the ecological balance. Again in 1987, the court was dealing with the tanneries discharging effluents into in the Kanpur district, and the court said the tanneries cannot function without fulfilling the minimum requirement of a primary treatment plant. So, if you do not have a mechanism to dispose of your waste, then you have no right to run a factory. In that context, the court said, just like an industry which cannot pay minimum wages cannot be permitted to continue functioning, a tannery which cannot set up a primary treatment plant cannot be allowed to function, as the adverse effects on public outweigh the loss of management and labor on its closure. Now, in MC Mehta versus Union of India, again in the year 1987, the court was dealing with Ganga water pollution. There again the court said that it is the duty of the central government under Article 48A, which appears in Part 4 of the Constitution, to introduce compulsory lessons on environment protection in schools. In 1992, in another MC Mehta case, the court gave directions to spread awareness on environment protection through mass media, information films and educational courses. What all in all some of these judicial decisions show to us is that the protection or conservation of environment, management of natural resources do not fall exclusively within the purview of the state or obligation of the state. All of us as citizens of the country or the people residing in India do have an obligation to create awareness and protect environment accordingly. In the year 1991, the court was dealing with the Lejano Teluk Environment Protection Group versus BSES company. This where the court was looking at the government's initiative when they are introducing public projects. The court said the government is to consider the importance of public projects for the betterment of the conditions of living of the people on the one hand, and the necessity for preservation of ecological balances, avoidance of deforestation that may be brought to its notice by various bodies of laymen and experts, and try to strike a balance in between these conflicting interests. Therefore, the court's role is limited to examine whether the government has taken all the necessary measures into account before granting license for a project or before approving of a public project. So, the court agrees that the public projects are for betterment of the life of people, but at the same time it cannot be at the cost of ecological damage. But then the court's role is limited to see whether the state has, the government has taken the necessary considerations while arriving at a decision in favor of a public project. In 1993, in Tarun Bharat Sangh versus Union of India, there was the issue brought into the notice of the court by the petitioner who was complaining about a protected forest in the Alwar district of Rajasthan being used where mining licenses were issued by the state government. Now, the court said the mining in an area which happens to be a protected forest is a non-forest activity which can be carried out by the state government only with the prior approval of the central government. And therefore, in the absence of a prior approval from the central government, use of protected forest area for mining purposes is not is contrary to law. The court went further in 1996 in Velu Citizens Welfare Forum and said that they used the precautionary principle and polluter pays principle, which by that time were part of international discourse on environment protection, and the court said these are essential components of the principle of sustainable development and part of environmental law of the country. So, the court acknowledged that any development needs to be sustainable, and in order to be sustainable they need to fulfill the principles of precautionary principle and polluter pays principle. and the court said these are part of the law of the country. So, therefore, we may not have a separate enactment as such, but these are falling within the environmental laws. And the court went further and said these are part of customary international law, and since there is no inconsistency with the national laws of India, these need to be incorporated into the national legal system. In 1997, dealing with S. Jaganath case, the court disapproved of certain practices which were part of the shrimp farming technology. The court said there are enough constitutional provisions and legislations like Environment Protection Act, Water Act, Fisheries Act, Wildlife Protection Act and Forest Conservation Act all suggest that intensive and semi-intensive technologies which are used in prawn farming in these days are not permitted. And the CRZ notification, the Coastal Zone Regulation notification, is to have an overriding effect over other legislations, since that is issued under the Environment Protection Act of 1986. In the Taj trapezium case of 1997, the court held that the industries of that particular zone using coke or coal are actually polluting industries, and therefore, these are damaging Taj as a monument, and therefore, the court suggested them to these industries to convert to natural gas or rather stop functioning and relocate themselves to any other place, but they cannot be functioning using these materials within the vicinity of Taj. In 1997, in MC Mehta versus Union of India, the court was brought to the notice of the falling groundwater level. The court accordingly directed the government to set up the Central Groundwater Board as the authority under the Environment Protection Act of 1986. In the Kamalnath case of 1997, the petitioners contested the lease of riparian land to a private company for commercial purposes on the banks of river Beas. The court held that this lease amounted to a violation of the public trust doctrine, wherein the state is the trustee of all natural resources to be used for the enjoyment of general public. So, that was one case where the court relied on the US decisions and introduced the public trust doctrine to the Indian context. Similarly, in 2001, dealing with Professor Naidu case, AP Pollution Control Board versus MV Naidu, the court said that the establishment of industries within the 10-kilometer radius of two major reservoirs of Andhra Pradesh, namely Usman Sagar and Himayat Sagar, falls within the clear prohibition, and state government cannot grant an exemption. So, the court did not approve of the projects. In 2001, dealing with the Delhi context in MC Mehta case, the court directed the phasing out of non-CNG buses from the roads of Delhi and fixed the time limit for the switchover to a CNG. Now, in 2004, the question about the legality of a mining activity happening in up to 5 kilometers from the Delhi Haryana border on the Haryana side of the ridge and in the Aravalli hills was raised before the court. After going through the background of the case and the previous orders, the court held that the Aravalli hill range needs to be protected at any cost. Therefore, a mining activity could be permitted only on the basis of sustainable development and on compliance of strict conditions. In 2005, in a reference noise pollution case, Supreme Court examined the implications of the noise pollution vis-a-vis Article 21 of the Constitution. The court was dealing with the case of noise pollution caused by the firecrackers, loudspeakers and vehicles in the light of the 2000 regulations on noise pollution. The court issued a direction to all the states to make provision for seizure and confiscation of loudspeakers and amplifiers and other devices which are causing noise pollution beyond the permissible levels. In the Kudankulam nuclear power plant project case, which came up before the court, decided in 2013, The court said that the central government and the state government have constituted committees. The committees were satisfied with the safety and security of the plant and safeguards, and therefore, all principles of sustainable development and its impact on ecology had been taken into account before approving the project. So, to sum up the discussion on sources of environmental law in India, we can see that there are binding obligations created through the constitutional instrument, the Constitution of India. There are a number of legislations which are enacted in the subsequent years and also particularly after the Bhopal gas leak disaster. We can see that initially India dealt with the environmental issues, not particularly emphasizing on environment as such, but through the criminal law mechanisms. But over the years, India has been developing specialized legislations dealing with environmental issues of different kinds. These are also supplemented by the rules, regulations and notifications from time to time. And Indian judiciary has played a pivotal role in developing environmental law for this country. This is in addition to the efforts of public spirited individuals like MC Mehta. One can see that the judiciary has expanded the scope of the constitutional provisions. It extensively used the specialized legislations on the subject matter, and it also tried to look at the role of the executive in the whole exercise. But at times the judiciary restrained itself by suggesting that if the matters are discussed by the government following the requisite norms, then it will not fall within the purview of the court to examine what the executive has been doing, because there is a clear demarcation of separation of powers. Therefore, the court could actually only look to the extent up to which the government has taken into account the necessary considerations before approving of projects. But overall, we can see a gradual development of environmental law discourse happening in the country and increasing awareness about environmental issues throughout the country as a whole.